Thank you for joining us this afternoon for Wayne State University Law School's third town hall on the COVID-19 pandemic. This week, we're talking about constitutional law and the coronavirus, from abortion rights to quarantines. We're joined today by Professor Lindsay Wiley from the American University Washington College of Law and Professor Anthony Kreis at Chicago-Kent's College of Law. Professor Wiley is the director of the Health Law and Policy Program at American. She's emerged as one of the nation's leading experts on the law of COVID-19. She's the president of the American Society of Law, Medicine, and Ethics. She's the co-author of a recently published paper in the Journal of the American Medical Association on presidential powers and response to combat COVID-19. Professor Kreis is a PhD in political science and administration, as well as a lawyer. His research focuses on the law's treatment of vulnerable persons. He is a smart guy, well worth listening to, and I'm really looking forward to the conversation with both of these folks. Before we start, I want to go over a few housekeeping items. Number one, if you're not talking, please keep your mic muted. We will do a Q&A with the panelists toward the end of the program. I encourage folks to ask a lot of questions, so just drop them into the chat box at any time. And when the time comes, I will read the questions from the chat box out loud for the Q&A. So we're talking about constitutional law issues here. And there are so many constitutional law issues here, and they keep on emerging. I want to start with one that's in particular been in the news lately, which is that at least 4 states have sought to use the current crisis to restrict abortion availability, classifying abortion services as non-essential services that are banned or restricted during the period of shelter in place. District court struck down those state rules in Oklahoma, Arkansas, Ohio, and Texas. But a week ago, the Fifth Circuit stayed the district court order pertaining to Texas, reinstating the abortion ban in that state. And by its terms, the ban in that state extends until April 21. Presumably, it's going to be renewed further. And it appears, now in its language, to even cover abortions for women who would be beyond 22 weeks, which is the legal limit for abortions in Texas, by the time April 21 rolls around. Now, as the case stands now, there's been a bunch of action in the district court and the Court of Appeals. As the case stands now, women who will be past that legal limit by April 21 can seek abortions. And moreover, medication abortions, those affected just by administering a pill, are now permitted. But the Fifth Circuit has allowed the state to bar all other abortions as non-essential services. So I'm gonna start us off here by turning to Professor Wiley. There's a fairly obvious argument that it's unconstitutional for the state to use the emergency to restrict abortions in this way. So how should we think about this? And did the Fifth Circuit do a credible job of arguing that it isn't unconstitutional?
I've been critical of the Fifth Circuit's approach to this issue, not just to its outcome, but also arguing that it was wrongly reasoned as well. I think that this has been a big week for Jacobson v. Massachusetts, a case that Lance and Seema and Heather and others on the call know really well. We tend to think of it as this really old case that not many people spend much time thinking about anymore until now. The Fifth Circuit, I think, really cherry-picked from Jacobson. Jacobson was one of the court's earliest attempts to articulate any judicial standard of review for thinking about 14th Amendment claims. It really wasn't just an emergency powers case. Also, to the extent that it expressed a need for stronger depth in an emergency, it expressed that with respect to legislative policy determinations, not necessarily executive policy determinations in a public health emergency. The Fifth Circuit, I think, very wrongly described Jacobson as the definitive standard for judicial review, implying that it applied to any constitutional individual rights claim, not just to abortion, for a public health crisis. I don't think there's support for that in the opinion itself. The idea that Jacobson, that if the court meant for us to pay attention to any Supreme Court decision post-Jacobson, it needed to say so in that Supreme Court opinion post-Jacobson, this is an exception to Jacobson, I think is pretty ridiculous. In terms of how states should decide, I argue in an essay, first a blog post that'll be followed up by an essay with my co-author, Steve Vladeck. Steve actually on terror, which I think has some interesting analogies in terms of an ongoing long-term crisis rather than one that is discrete and of limited duration. We argue that that the suspension approach, which I think the Fifth Circuit is really trying to use Jacobson as a kind of suspension rule, that there's a Jacobson standard of judicial review that applies in a public health crisis, that approach is the wrong approach to upholding orders, that the vast majority of the COVID social distancing and preservation of PPE orders will be upheld under ordinary standards of review that have been carefully crafted and well vetted over decades, as opposed to reverting to some kind of extra constitutional test. The other example for that suspension approach is a trial court in New Hampshire that was one of the first courts to review a challenge to an emergency social distancing order for COVID, explicitly adopted a suspension rule. And the test that they borrowed from an 11th Circuit decision post-Hurricane Andrew about a curfew that had been imposed for a couple of months every night after the hurricane, that standard was a good faith test alone, good faith and some factual basis, which is actually beneath the rational basis review standard. I also think, even aside from whether you treat Jacobson as the definitive test for a public health crisis for judicial review, I also think the court mischaracterized the level of review that Jacobson imposes. I think there's something in that opinion for everyone, but by ignoring the consistent with public health necessity language in Jacobson, the court really characterized it as mere rationality review, and I don't think that's quite consistent with the way Jacobson has been interpreted in other contexts in the intervening 115 years. I'd love to hear what Anthony thinks, though.
Right. I realize before I toss this over to Anthony that for the benefit of a bunch of folks in the audience, I should just take a minute to explain what Jacobson was and what it was about. Since this is back in 1905, the issue is whether local government can mandate smallpox vaccinations. And the claim is made, no, I've got control over my body. I have a right to decide whether I'm vaccinated or not. The state can't force me to be vaccinated. And the Supreme Court, treats this as a, due process challenge in that nascent era of due process challenges back in the Lochner era, and says in essence, well, this is going to be subject to a reasonableness test. And indeed, especially given that we're in an epidemic where different folks' ideas of what the very best response, different reasonable people's ideas of what the very best response to an epidemic is might vary. We're not going to second guess the legislature too hard on that one. But it does seem as if what the court is saying is that it's applying a general standard of due process reasonableness rather than the message the Fifth Circuit seems to have taken from this, which is that, well, gee, in a public health emergency, all bets are off. But Anthony, let me throw this one over to you.
Yeah, so I approach a lot of these cases from not really the public health perspective, but I think of them more in terms of the jurisprudential development. And for me, as someone who's done a lot of work in the law and religion space, I've always thought of Jacobson as standing for a proposition about you don't have a right to object to a public health order when that objection can cause third-party harms, right? So for me, it's one of the big takeaways has always been about the harm an exemption or an exception can cause to other people. And so for me, right, the kind of misuse of Jacobson by the Fifth Circuit is, in a way, right, no one is harmed by deeming a critical medical service or access to reproductive health care. Like that does not pose the same kind of harm, third-party harms to the community that not wanting to be vaccinated in the wake of an epidemic poses. So I agree, right, that the Fifth Circuit is doing something with this case law in order to achieve some kind of ends that the precedent doesn't stand for. But what I do think is interesting as a law and society person is that courts are, that this, in many ways, the COVID-19 crisis has been a microcosm of these very pitched social, contentious social battles, which the courts have been, mired with for years now. So not only do you have these questions of, is reproductive health care an essential service in the time of a pandemic, but then you have other questions about, are religious services an essential kind of service, and what kind of exemption should be placed for them? How about gun dealers and people who sell guns? Is that a Second Amendment value that should yield to the public health crisis, and how do we deal with that? So it's been really quite a fascinating few weeks to see, these long-standing debates about abortion and gun rights and religious liberty, which have been in the middle of our constitutional battles for the last 10, 15, 20 years and then some, be kind of relitigated in this moment in time. And I think that's a particularly telling just dynamic of where we are in our constitutional order and in constitutional time. And I think it's really telling and interesting and fascinating to see what courts are willing to do with these rights claims in the middle of a pandemic. So, so I would agree completely that Jacobson was misused by the Fifth Circuit. But I would probably go, maybe not a step further, but I would just add that my view is that it's opportunism, right? That the Fifth Circuit is taking this opportunity to deal a blow to abortion rights, which they've been, chomping at the bit to for a long time already.
Can I just jump in really quick with one other bit of context for the abortion cases specifically? I think it's useful to understand that we've been referring to whether abortion is an essential service or not, but that's coming from a different type of social distancing order. The abortion restrictions are coming from not for the purpose of social distancing, but allegedly for the purpose of preserving equipment, preserving supplies and preserving healthcare capacity. So it's both about, is this encounter with a patient creating an opportunity for close contact, right? Similar to why we would shut down any other non-essential business to increase distance, but also a set of considerations about equipment, capacity, supplies, in the healthcare sector specifically. And I think on both points, experts have pointed out that the court really doesn't engage with the facts, the realities of what various kinds of abortion care. And also I'll point out that the restriction doesn't, the abortion aspect of it, its applicability to abortion has garnered the most attention, but states are actually varying in whether they are deeming all family planning services to be elective or not. So it's not essential or not, it's elective or not in most states, or time sensitive or not. And the states that have specifically exempted family planning from their restrictions on elective or non-time sensitive care have done so not just with respect to abortion, but with all family planning services, which could be particularly crucial at this time when we know that family planning access to family planning care can be an important aspect of establishing dynamics within intimate relationships at a time when those relationships are being put under enormous strain because of the stay-at-home orders and economic effects of the crisis as well.
I just want to underline that bit about Texas and the Fifth Circuit's order. Texas's primary rationale or primary articulated rationale for shutting down access to abortion services is essentially that when clinics provide abortion services, they use masks and gowns, or at least when they provide non-medication abortion services, they use masks and gowns. And we need to preserve those masks and gowns for other uses by other medical personnel. The response of more or less every one of the 4 district courts to have considered this issue is, are you kidding me? That if we try and weigh in the balance, the availability of abortions as protected constitutional rights against a small number of masks and gowns, and we're not even talking N95s here, we're just talking standard paper masks and gowns, it's really hard to say that the incremental availability of masks and gowns should weigh more heavily in the balance. But that's not how the Fifth Circuit, which has historically been a highly opportunistic court, has seen it. Anthony, I just want to push back a tiny bit on the concept of third-party harms here. Because if our focus is on third-party harms, isn't that in this context enormously empowering to the state and enormously disempowering to any individual claim for exemption? Because all of the state's arguments in the context of COVID-19 are about third-party harms. If you do this thing, you might increase the opportunities for contagion for other people. You might decrease the availability of PPE for other people. So I would think that's really a route to the state being able to do pretty much anything at once.
Yeah, I mean, I think that, so, I'm loath to bring in my legal realism too much, but I think that's just the the reality of it is that courts are going to be very hesitant to question the judgments that are made by public officials, so long as they have some basic level of facts to back up their position. So, certainly that's ripe for abuse, right? That, without some kind of very robust judicial review, certainly you can have mayors and governors and county, executives and the like, issuing orders which are really quite overbroad and overly restrictive, perhaps, of individual rights, but aren't going to get the kind of treatment in litigation that they might otherwise receive and deserve. So I do think that that's a real risk, that this idea of suspension, this idea of everything's a third-party harm, the fear of judges perhaps that they don't want to intervene, even if there is some evidence to suggest that that state and local officials or even federal officials are really acting outside of or acting in a way that is more aggressive than necessary. I think that's just a real risk, and we have to, as members of the legal community, I think we do need to be very, very skeptical and cautious. We do need to question and to really explore and to think about the kinds of policies that are being enacted, and whether they are overbroad and whether they have some discriminatory effect, and whether there is better science to out there to justify maybe paring back some of these more restrictive policies. And that's important, but it's important to have experts, right, leading that conversation. And so one of the concerns that I have is that, I make it very clear, for example, I'm not a public health person. I'm not a doctor. I don't have public health training. So my worldview, and when I come at these issues, it's from a very fairly bland constitutional law perspective, law and social change kind of perspective. I feel like it's my duty to defer to good quality, research and evidence and the like. What we can't afford are, law professors or, economics PhDs acting as armchair epidemiologists, and trying to drive public policy in a way that they have no expertise in, or really any business in doing. And that's really my big concern in terms of both general policy making and policy decision making, from like a public administration background, but it's also a big concern of mine in terms of litigation. are you going to have these faux experts affecting the way judges think? Because I think that's incredibly dangerous. So yes, we want judges to be good consumers of public health data. We want them to be good consumers of different arguments and to really think through the different policy decisions that have been made in the wake of this health crisis. But we need people to, we actually really need expertise. This is not a time to tap into an anti-intellectual tradition.
I can just respond to or jump off of a few of those points. And I think Anthony and I are, I would in no way characterize this. Your hair just as Anthony. Sorry, it's fun to watch. So a few things. First, on the other regarding versus self-regarding harm, I just want to flag something that hasn't gotten much attention, but that I think will emerge as a more and more important issue as this crisis wears on for months to years. And that's orders for people at greatest risk of COVID mortality to shield themselves. So Oklahoma right now is one of the few states that does not have a statewide stay-at-home order that's generally applicable to the general population. What they do have on the books, although I'm not aware of any enforcement that's been undertaken, is what is characterized as a mandatory order for people at high risk of COVID mortality by age or based on underlying medical conditions to stay at home. And that, I think, presents distinct issues. One question would be, at some point, is there some argument on behalf of the collective society that it is an other regarding choice for someone to not stay at home based on their own higher risk? Because, in some way, well, if you go about your business and are not only restricting yourself to essential tasks outside the home, you're going to occupy a bed that someone may need to be out and about for essential tasks would otherwise have access to. So I think we're going to see more and more stretching that other regarding versus self-regarding. And I say that, right now it's just Oklahoma, but over the long duration, we're seeing in other countries that have started to ease restrictions, we're seeing calls for people at higher risk to actually do even more to shield themselves as others start to return to some level of economic or social or educational activity. And so I think, even as we ease restrictions on the general population, those recommendations, and I say recommendations because I think mandates would be deeply problematic for people to shield themselves if they're at higher risk, are going to be more and more a focus as we start to ease restrictions on the general population. I also want to jump off of Anthony's point about science versus values here. I think, I am a strong proponent of the role of expertise, of deference to expertise by the best available evidence. But I want to say, though, that with coming with only my lowly master's degree and speaking on behalf of public health, at least for this audience, I want to acknowledge that this is not a set of questions or choices that can be made based on objective scientific evidence alone. Right now we're at a point where the courts are, and the states and local governments who are defending their restrictions are sort of all assuming that there's no question what the goal is for these orders, that the goal is, fighting COVID. But there is actually a set of choices. And we've seen these compacts on the West Coast and East Coast forming to start thinking about long-term strategies. Really the starting point of those discussions is whether our goal is suppression of the epidemic curve to make it as flat as possible, to have as few possible in as many places as possible, or whether our goal is to flatten the curve in a mitigation mode to keep it within existing healthcare capacity, even as that capacity is being expanded as rapidly as possible. And that is a choice that has to be guided by science, but it has to be made based on values as well. And I think we're going to start to see more of a need for democratic deliberation on that. It's not the same kind of urgent immediate, someone needs to make a decision right now that we saw with imposition of the stay-at-home orders. So I think the courts actually have a role to play over the longer term in requiring officials who are defending their orders not only to discuss whether there's a means ends fit, but really to articulate those goals in more specific terms so that then political checks can be more effective, because the goals are not being stated clearly yet. And then one last point, which is how does scientific expertise guide the courts in these challenges, especially when we're talking about, TROs and preliminary injunctions, and we're not talking about, gathering lots of evidence or discovery. In past crises, if we look at challenges to Ebola quarantines, if we look at even farther back to challenges to smallpox quarantines, the courts have really relied very heavily on guidelines from CDC to, and state and local governments have federal guidelines really for cover for their decisions. It's seen as a kind of, well, look, we did what CDC told us to, right? And the courts are very comfortable with that, as opposed to, well, the state's expert says this is what's needed. And the CDC's role there has been really problematic in this crisis. They have issued a mitigation strategy, although it does not use the word guidelines or guidance in it, and it's not clear who wrote it, and it's not clear how it ended up on their website. It was put up pretty early on, but it is in direct conflict with a set of guidelines and called guidelines that are hosted on the whitehouse.gov website. And basically you go into CDC's guidelines and you see a banner that says, go to the whitehouse.gov website and see the guidelines. But then underneath that are some really specific that are in conflict with that White House policy. So I think one of the things we're seeing here is, there's a lot of focus on how the federal government's role with respect to social distancing is advisory, not mandatory. That certainly was in the news yesterday again, with the president arguing that his authority, including over social distancing orders, was absolute. But even that advisory role, I think, shouldn't be discounted. It provides cover to states when there are clear guidelines for social distancing, and that's something that's been lacking in this crisis.
So I guess I should ask this question then, seeing as we're in a constitutional law context. Does the president have absolute authority to open up the economy?
Anthony, do you want to start, or do you want me to take a crack?
I'll start. Well, I
have my own views about this.
Yeah.
Go ahead, please.
So I'm really quite skeptical of any argument that there's some kind of an inherent Article 2 plenary power to force governors to do something one way or the other. This really is a question for state and local officials. But I think that in that sense, federalism has been pretty, has been an asset, right? Where you have, for the most part, governors who've been doing a really fantastic job. I think that, if you look at California and Ohio's governors, for example, I think they really stepped in early and took charge and were very good about explaining to the public why they were doing what they were doing. And, meanwhile, you have, Florida, for example, with Governor DeSantis kind of dragging his heels forever and ever and ever. So that, that shows both the upshot of the federal system and the downside. But that being said, I still, I'll kind of piggyback off, what Lindsay was just saying about the CDC. You still need federal guidance, right? So just because the federal government doesn't possess the power to open and shut open and shut business on a state-by-state level or state-by-state basis, does not relieve the federal government of a need for leadership, right? That is what's so crucial here is you need federal level, national level leadership in conjunction with good coordinated efforts on, by governors and state and local officials. The reality is that because of that absence of federal leadership, you're seeing states take it into their own, fill the vacuum with these regional compacts, which I think is a really interesting development in terms of, just observing federalism and this kind of practice of regionalism that's emerging. But that's, I think it is important to have, national leadership, even when the power to open and shut the economy, for lack of a better term, doesn't rest with the president. And it's that to me is the real I guess tragedy of all of this is the these governors would be so much better off with leadership, and that is just so lacking right now. And so I can only hope that, in lieu of the CDC being, the real leader here, or in lieu of the president being the real leader here, and giving the kind of guidance necessary, that perhaps, some of these regional compacts can fill some of that void. But I still don't think it's going to be able to have the same kind of, currency or power as having one voice, from the federal government leading the charge, right? And I think that's something that we are desperately in need of.
And if I can just jump in, I want to hear Jonathan's thoughts on the constitutional law issues, but just to offer a little bit of a public health perspective on this question. I just want to clarify that it's not that the CDC guidance even should say this is what should happen right now with non-essential business everywhere throughout the country. There's been this desire on the part of some portion of the general public, and maybe more so on the part of kind of blue state voters or people who lean liberal, for uniformity in these decisions. There's this sense of anxiety that we're not all doing this the same way. And I think from a public health standpoint, that's not actually right. That's not actually what's needed. That this crisis is not affecting all places in the same way at the same time. It's going to affect different places differently in different times. And so these decisions have to be made based on local conditions on the ground. But CDC guidelines don't work that way. The CDC mitigation strategy that does not use the word guidelines is actually based on conditions on the ground. It's a set of criteria. It's almost like an algorithm, a decision tree that says, if these conditions are met in your local area, these are the things that should be done. And it may or may not be the right set of things, but that's the right, in my mind, that's the right kind of format for that federal guidance. My perspective is that state governors can and should, from a public health standpoint, hold the reins on social distancing orders. But I'd be curious to hear from you, Jonathan, as well.
Well, before I speak to the constitutional issue, I just want to ask you a bit about uniformity, since I would have thought that we do need some level of uniformity in the sense of everybody pursuing roughly the same algorithm. That if Michigan is saying, well, gee, we can't relax social distancing unless we have reason to think that by virtue of testing or contact tracing, we can safely relax social distancing. And Ohio says, well, we've got no testing or contact tracing in place, but we're just going to send everybody back to work next week and, let the devil take the hindmost, then Michigan's in a lot of trouble. So that sort of non-uniformity seems as if it would be a problem.
So I'd like to invite Anthony to weigh in on a specific aspect of this, which is this. I think that problem, so these compacts so far are based on geographic contiguity, right? Shared borders for that reason. The idea that, one state can't choose to let the epidemic burn through its population, which is the third way, right? That I haven't mentioned, that's sort of at least on the table in discussions, and then have the state next to it decide to pursue a suppression on the curve, to the greatest extent possible. That just doesn't work. That's as much because of the infeasibility and constraints on travel restrictions as anything else. And so you could see different levels of social restrictions, different levels of social distancing orders in different places. And actually you have seen that. I mean, China did not uniform social distancing requirements in every province. They had a lot of variation based on where the outbreak was being and to what degree in different places at different times. What they did have was very firm restrictions on travel among those provinces. So I'd like to hear from Anthony, because I know he wrote very law review blog about this travel issue, and I think that's crucial to thinking about the disuniformity aspect of a federalist response.
Yeah, so I think what you would, I think, for example, Indiana, right? So Indiana has a lot of individuals who work in the Chicago area. And so, right, so if Illinois, takes one track and Indiana takes another, right, that is a very incredibly problematic dynamic. And, so I think that's why those regional compacts are, so important. But if they don't exist, you could see a scenario where an Illinois might say, well, if you travel to Indiana, that's fine, but you have to self-quarantine in Illinois for 14 days before you're allowed to travel intrastate, which is kind of reflective of what some of these other, some other states have done in, Delaware and or Delaware, Texas, Florida, which have said if you're traveling from a particular jurisdiction, you have to self-quarantine for 14 days before you can travel intrastate, which, essentially, right, bans all short-term visitors and would prevent anybody who works in Illinois, in this hypo, anyone who works in Illinois but lives in Indiana from going to work, even if Illinois relaxes some of the essential restrictions on essential workers. So there's a real constitutional question there of, can you do that? And I think for the most part, so long as you're treating out-of-state residents and in-state residents the same, that's one big touchdown. But then I think the other question is are there less restrictive alternatives? And unless you have, I think, rapid testing available at scale, and you have other measures in order to really, essentially, I guess, really change your model of responding, to the pandemic. Those orders, I don't think, would necessarily be successfully challenged in federal court. But again, right, that as this goes on, and the more technology, the more knowledge we have, the more capacity we have to test and understand incubation periods and things like that, I think courts would be more suspect of those very broad 14-day, self-quarantine orders. But that's really, I think that's why we're moving towards the regionalism approach, is to avoid that kind of dynamic where you have to make those tough decisions because one state is just so recalcitrant. But you might see that in some places, I say Florida and Georgia. You might actually see that kind of dynamic happen. I don't know, but I think that's why the regionalism approach is so important, is to avoid those kind of thorny issues that you don't really, nobody really wants to be in that situation, I don't think.
I want to push a little on that least restrictive means or narrow tailoring analysis, since I figure that if the state can impose a 14-day quarantine requirement on people coming in from out of state, that's got to be premised, at least to some extent, on the idea that people coming in from out of state present a greater risk than people the people already within the state. And by now, I think the majority of states have 14-day quarantine requirements in place. Last I checked, it was 34 that had them in place. But there was a period when South Carolina had a quarantine requirement for people coming in from New York, New Jersey, and Connecticut, and it had no shelter-in-place requirement in place for people within the states. And I would have thought there's a really good argument that fails any kind of narrow tailoring test. If you're not taking this virus seriously enough, even sufficiently to impose a in-state shelter-in-place requirement, but you're still telling people from Connecticut, oh my God, you're from Connecticut, where those, effete foreign disease-ridden Northeasterners are. You've got to quarantine for 14 days when you come into South Carolina. So yes, no?
Yeah, so I'd like to weigh in on that first from a public health standpoint, and then touch on some of the legal aspects about whether least restrictive alternative is actually required for individual quarantine, which is what we're now talking about. This is very different from mandatory stay-at-home orders, but really individual quarantine, which is far more of an imposition on individual liberty than a stay-at-home order. First of all, from a public health standpoint, I should disclose that I don't consider myself a South Carolinian, but I lived there among many other places as an Air Force brat. I went to high school there and have a lot of connections there. It's not just about how seriously you're taking social distancing. The variation is also about the level of community transmission in a place. And so I don't think it would be right to assume that the justification, that the argument that a traveler's quarantine should only be based on the level of restrictions that it imposed, right? So let's imagine Hawaii, for example. gets to a point where it has assessed community transmission through a combination of testing and other non-testing measures, which CDC has endorsed or somebody at CDC, there's no name on the document, has endorsed as an appropriate way to assess community transmission. They've decided that their outbreak is largely under control, that their level of community transmission is quite low, and so they ease, most of the social distancing orders. But there's still reason for them to think, but somebody coming from somewhere else, which may have more stringent restrictions than we do, would pose a greater risk. And I think there's an argument that in the outbreak and even today, aside from social distancing orders and how stringent they were, someone who has traveled in the New York City area has probably been exposed to a greater likelihood of contracting the virus, because the level of community transmission there is clearly widespread, than someone who's been in South Carolina for the preceding 2 weeks. I also think this of travel quarantines to be more important as we learn more about different levels of community transmission in different places, and of community transmission are affected by different approaches that state and local governments are taking. And so let's talk a little bit about those individual quarantine orders. There are public health law scholars have argued strongly that strict scrutiny is required, that you have to demonstrate the least restrictive means. And there are also procedural requirements that would be triggered as well, right? If we think of quarantine that way, that there has to even be a hearing right. Federal quarantine orders are far more rarely used than state under regulations, not as a matter of constitutional requirement necessarily, but they require representation by people, a right to a medical hearing with representation to challenge that order for any individual who's subject to it. Just requirements that just are not going to be seen as logistically feasible at the mass scale that we might be talking about. But courts, the federal courts that have heard challenges to individual travel quarantine orders, and there are very few decisions in this area, have not clearly endorsed the idea that the least restrictive alternative or a procedural due hearing right is required. That argument is based actually on involuntary commitment proceedings for people based on mental health conditions. And the question is, does that same jurisprudence that's much better developed in the mental health space apply to the infectious disease context? The courts that have heard challenges on that have acknowledged that argument. And for the most part, they have assumed without deciding that the least restrictive alternative is required and that procedural protections are required, and have found those requirements to be met in individual cases. But even that is not uniform. And cases decided after Ebola quarantines were imposed on travelers have actually reached the conclusion that strict scrutiny does not apply. And they've relied on Jacobson, again, as an alternative standard that is more deferential. I think we'd likely see the same thing. So I think we will see challenges to travel quarantines as this continues to play on, and as enforcement of them gets more stringent. And I think in those challenges, we're likely to see a resort to Jacobson again, to say that just to avoid what would be seen as a logistically impossible requirement, particularly in terms of the procedural requirements that would be imposed. Just one last thing on that individualized risk assessment. For Ebola, there was very strong understanding that asymptomatic spread was not a problem. And so there wasn't testing, that was clearly going to say whether somebody was at risk of spreading, but there were symptoms that gave a very strong indication. And so individualized risk assessment of travelers was not nearly as challenging as it is for coronavirus, where the current best available evidence suggests there's quite a lot of asymptomatic spread that's happening. So that individualized assessment, if it's required, will be harder and would have to be based on things like, where have you been in the last 2 weeks and how careful have you been? And that relies a lot on, people telling the truth and recalling accurately what they've been doing. So it creates some really challenging issues for individualized assessment in this space.
I want to turn now to a couple of the questions in the chat box. And one of them was dropped in by Professor Gable, and it's actually relates to some of the stuff we've been talking about. You know, he asks, as time goes on and some of the social solidarity that we've seen so far with, you know, relatively widespread voluntary compliance with stay-at-home orders, some of that social solidarity begins to wane. You know, what are some of the constitutional and practical issues likely to arise with mandatory orders? And before tossing this over to you folks, you know, I'll just mention that we're already beginning to see these cases hit the courts. You know, we saw an opinion handed down just now in Pennsylvania with the wonderful, wonderful name of Friends of Danny DeVito against Wolf. This is not that Danny DeVito. It's a completely different guy named Danny DeVito who's running for office in Pennsylvania. But, you know, that's got a disparate set of plaintiffs. Some of them businesses. They're characterizing the state's order requiring their businesses to be shut down as a violation of the takings clause, as a violation of procedural due process. In the case of Mr. DeVito's political campaign, as a violation of the First Amendment. Pennsylvania Supreme Court didn't think too much of any of those arguments. Where we're seeing more successful arguments have been from people raising religion claims. There was a very high profile judicial opinion in Kentucky taking the position that it's unconstitutional, at least in certain circumstances, for a shelter-in-place order to apply to church services. We saw a lawsuit here in Michigan by someone seeking a declaration that the state shelter-in-place order could not constitutionally bar his picketing an abortion clinic. That one's not going to be litigated because the state has backed down. Governor Whitmer has shown no interest in, it appears, in having her order apply to anything religious or religion adjacent. But let me toss over to you, to Lance's questions. You know, what are the sort of issues that we're going to see as people begin chafing at the nature of these mandatory orders?
So really quickly, I think we're already seeing that happening to varying degrees in varying places. And it may be that from where you sit in Detroit, in one of the hardest hit areas in this current wave of outbreaks, it looks a little different from where folks sit in places where it's not hitting as close to home. But, you know, my perception is that once you hit the kind of 2-week, 14-day quarantine mark, and people who are you know, relatively well off, relatively secure in their sense of their ability to control their exposure, felt like, oh, I've hit the 14-day mark and I didn't get sick and die. You know, you start to hear questions about, well, I'm not as afraid for myself anymore. And now I'm thinking about whether I'm really willing to do this for the society as a whole, for other people, to protect other people, right? I want to start making my own choices about what level of risk I'm willing to experience. And it's not unlike vaccination, that at that point it becomes a question of what we can require everyone to do for the greater good, as opposed to what people are strongly motivated to do out of fear for themselves. I think, you know, my main point from a public health perspective, my prediction would be to expect these kinds of questions about just every aspect, every detail of the distinctions that a law draws. And you know, I would add, Jonathan, to your list, equal protection, which we're seeing in Massachusetts with the dispensaries, the application to marijuana, or some marijuana dispensaries and not others. I think those disputes are only going to get more challenging, because you're going to see less uniformity in the response, not more uniformity in the response as time goes on, both because there are value judgments, political, true policy questions that are involved, and also because the outbreak is going to impact different areas at different times in different ways. And so there should be variability. I think elected officials are going to be in the position, subject to potential intervention from their legislatures, of having to constantly adjust that level of social distancing in response to new information about the outbreak. You know, ease restrictions and retighten, and ease and retighten, all while thinking about travel restrictions and limits to protect kind of the different levels of transmission in different areas. And that's going to raise all of those individual rights issues that Jonathan mentioned, as well as every separation of powers and federalism constraint imaginable too, because there are going to be different authorities continuing to claim the power to make these determinations, and voters may want to weigh in directly as time wears on.
And here, I think, by the way, is a really important time to circle back to your earlier point, Lindsay, about differential restrictions for high-risk individuals. Because the key point Justice Jackson made in his Railway Express concurrence is it's harder for a legislature to impose restrictions when they apply to everybody. And it's much easier for a government actor to impose restrictions if they apply to some people, but not to politically influential folks. Because then, you know, politically influential folks are happy and nobody else matters. But Anthony, thoughts on this?
Yeah, I would just add that I think this is really, you know, the constitutional questions will get harder over time, but I think this is really a primary question about political leadership and the ability of elected officials and public health officials to communicate clearly to the, you know, the citizens that they serve what they're doing, why they're doing it, and why compliance matters. And if that kind of communication is, is maintained and effective, and facts are presented, that makes it a lot easier, I think, to get the public's buy-in. What you can't have is conflicting messages and people, just as an assumption that people are going to comply because you tell them to. You really need, the elected officials really need to get the public's buy-in, I think. And I think that's a really crucial dynamic, perhaps even more crucial than any of the constitutional issues, which will inevitably crop up.
Okay. We've got one more question in the queue. This is a bit more detailed than our conversation has been so far, since we've been having this conversation mostly at 30,000 feet. But the question is, the speakers were critical of the Fifth Circuit's holding and reasoning with regard to abortion services. Texas and other states' executive order restricts access to other types of surgical treatment that are widely regarded as medically necessary, but not immediately necessary to correct a serious medical condition or preserve life. Biopsies and colonoscopies that are medically necessary to diagnose and plan treatment for various forms of cancer, for example. Does the same 14th Amendment argument apply to non-abortion aspects of the executive orders?
So I'd like Anthony to answer the con law part of that question, but I'll just provide some context in terms of what different states are doing in this space. States have taken very different approaches to their restrictions on elective procedures. But I think the better approach here has actually been to describe procedures as time sensitive or not. And that would certainly encompass cancer-related care. And I think the best approach has actually been to be strongly deferential to hospital guidelines, to professional standards of care in that space. Now, there's a problem with doing that, which is that although we don't like to think of it that way, healthcare is a business like any other. We wouldn't defer to, for example, Walmart about its determination about whether the kinds of things it sells are essential or not, because it's always going to decide that the things it sells are essential. And healthcare providers might be in the same space. There might be strong, they are very economically impacted by these restrictions and have strong incentives to return to high levels procedures. But I just wanted to kind of put out there that there are various options for thinking about how to draw designations between different types of care.
So, I think the key here is that, just operating from a background knowledge, like, it is clear that certain states are taking certain positions on abortion access because of political reasons, right? There's a reason why Texas is doing it, and there's a reason why Illinois is not. And it's not because the dynamics on the ground are all that different, that require abortion to be treated differently in Texas than it is in Illinois. It's just a political attempt to deal a blow to abortion access and to reproductive justice. And the question is just whether the courts will permit it. And the Fifth Circuit, again, I think has just, essentially blessed what they've always wanted to achieve. And I think there's a real danger in courts, trying to make inroads jurisprudentially, in a time and use the time of crisis to take advantage of the crisis. Similarly, to kind of piggyback off of what happened in Kentucky, you had a TRO imposed by Judge Walker against the city of Louisville against an order that didn't exist, because he just took a church's word for it and then railed against the city of Louisville as criminalizing Christianity on Easter Sunday on facts that were just not substantiated at all, both in terms of what legal mechanisms were in place, and as well as there was contested, the facts themselves were contested about what was happening, by certain churches in Louisville. So, to me, the real concern is, are courts being level-headed in their approach, or are they, taking advantage of the moment to pursue, an agenda? And I think that's what the Fifth Circuit's done. And again, I think that's why Texas has responded in a way that Illinois has not, or some others, New York, for example, why is it that Texas is so desperately need to restrict abortion access, but New York and New Jersey don't? I think these really are deeply political questions, and that, I guess that's just my take on it.
Certainly, there's no time like a crisis to pursue an agenda, and we're seeing that on a wide range of fronts, only some of which relate to constitutional law. We're nearly out of our time. We've spent less time than I had sort of figured we might, talking about structural issues, federal government versus states, separation of powers within the federal government. Seems to me, just as a matter of constitutional doctrine, a lot of commentators have been way overplaying the power of the states to remain free from and to ignore federal mandates. Folks are saying that the federal government, could not pass a law simply preempting state shelter-in-place orders, which seems to be, as a matter of constitutional doctrine, wrong. The case law suggests that the federal government does indeed have that authority. It's the case that the president can't do that unilaterally as a matter of separation of powers. It's why we have separation of powers, such as that would need to be enacted by the House, passed by the House, passed by the Senate, signed by the president. But there's ample case law that would be something within the authority of the federal government, which is why I think probably it's just as well that the federal government as a whole has no intention of doing that. One more question, just as a matter of quick hits and 30-second answers. The use of the time of crisis to advance abortion policy goals by the courts could be similarly applied to the recent Supreme Court decision about the Wisconsin election. How does that relate? And I'm going to ask for 30 seconds from both of our panelists, and that's going to close out the session.
Yeah, absolutely. This is a situation then where it's the government's decision about public functions, the performance of public functions, that comes into play. With respect to voting, if it were apolitical, it would be, I think, an obvious choice to increase distance voting in whatever form that may take. But it's highly politicized, and I think it's been actually stunning the extent to which people have been open about the political considerations that are shaping their views.
Yeah, I think the same. I would agree. I mean, I don't think it's any surprise when you look at the split, both of the Wisconsin Supreme Court and the U.S. Supreme Court, and then you look at the political breakdown of the reactions from Wisconsin legislative leaders, and a lot of the discussions around mail-in, vote by mail being resisted by conservatives as it will be the death knell of the Republican Party if we let people vote. I don't think you can separate the political considerations from the constitutional analysis here. It's just a bottom. The bottom line is that there is a fear that greater access to voting will be a political damaging calculation or politically damaging policy, and I think that's operating in the background behind a lot of these decisions.
All right. we are out of time. I want to deeply thank our speakers, both of whom have been terrific, and to thank all of you who are watching for showing up. We are going to be emailing out a recording of this program, and thank you so much. That's it for today.